5 seconds to go. Start. He submitted that income tax department is adversely affected due to the order of status quo passed in this appeal, as 162 out of 486 sanctioned posts of income tax officers are vacant. He submitted that this had drastically affected service to the taxpayers. He submitted that 109 income tax inspectors are likely to be deputed for election duty of Gujarat Assembly elections. He submitted that non-convening of DPC for ITOs is having cascading effects, as there are least number of promotions in Group C cadre. He submitted that if this court is inclined to refer the question to a larger bench, the interim order may be clarified or vacated, as the functioning of the department is really affected by the interim order. The learned senior counsel appearing for the appellants by way of rejoinder submitted that direct recruits are selected by SSC by open examination, which is conducted annually. Therefore, SSC follows the calendar year as opposed to the financial year. He submitted that as no recruitment occurred in 2009, the results of the 2010 examination will determine the seniority of carried forward candidates. He also pointed out various documents in support of his contention that a recruitment year will have to be taken as a calendar year. We have carefully considered the submissions. The first issue which arises for consideration is whether the decision of this court in K. Megha Chandra's case is per incurium, or in the alternative, whether it requires reconsideration, being in conflict with the decision of the Constitution Bench and the decision of a bench of 3 honorable judges in the case of M. Subba Reddy and another versus AP State Road Transport Corporation and others. The next issue will be assuming that the decision of this court in N.R. Parmar's case stands overruled in view of its prospective overruling, whether the inter se seniority of the direct recruits and the promotees in the facts of this case could be determined as per the decision in N.R. Parmar's case. This is in the context of the fact that the seniority was fixed after the decision in the case of N.R. Parmar and before 19th November 2019, that is, when the decision in K. Megha Chandra's case was rendered. The third issue to be decided is whether the recruitment year is a financial year or a calendar year. Lastly, a factual issue will have to be decided whether, in the facts of this case, the process of recruitment of candidates. Therefore, the amended seniority list dated 13th February 2018 was illegal. Now coming to the decision of the bench of Honorable 3 judges in the case of K. Megha Chandra, this court was dealing with the Manipur Police Service Rules 1965, for short the MPS rules. This court was dealing with the issue of the dispute over the seniority in the cadre of Manipur Police Service Grade 2 officers between the direct recruits and promotees. After referring to Rule 28 of the MPS rules, a finding was recorded that the rule expressly provided that the seniority shall be reckoned only from the date of appointment and not from the stage when the requisition for the appointment was issued. In paragraph 34, this court held thus: the judgment in N.R. Parmar 2012-13 SCC 340 is now to be considered in some detail, as this is heavily relied on by the appellant's counsel. At the outset, it must however be cleared that the cited case had nothing to do with the MPS Rules 1965 and that litigation related to the income tax inspectors who were claiming benefits of various central government OMs dated 22nd December 1959, 7th February 1986, 3rd July 1986 and 3rd March 2008. The judgment was rendered in respect of the central government employees having their own service rules. The applicable rules for the litigants in the present case, however, provide that the seniority in the service shall be determined by the order in which appointments are made to the service. Therefore, the memorandums concerned referred to in N.R. Parmar 2012-13 SCC 340, which deal with general principles for determination of seniority of persons in the central government service, should not, according to us, have any overriding effect for the police officers serving in the state of Manipur. In paragraph 38, this court held thus: at this stage, we must also emphasize that the court in N.R. Parmar 2012-13 SCC 340 need not have observed that the selected candidate cannot be blamed for administrative delay and the gap between initiation of process and appointment. Such observation is fallacious inasmuch as none can be identified as being a selected candidate on the date when the process of recruitment had commenced. Stop.